Hi, I'm Andrew Flusche, your Virginia traffic and misdemeanor defense attorney. Today I want to talk to you about a really simple issue in the law, and basically it's what's known as constructive possession. But a specific issue of that is, can you be found guilty of possessing contraband, in this case drugs, simply by sitting in a vehicle with that substance visible in plain view? Let's talk about it. There's a really good case directly on point in Virginia about this. It's called Coward versus Commonwealth. It's really easy to remember because it's kind of an interesting last name. So in Coward versus Commonwealth, you have two people in a vehicle, a driver and a passenger. The police pull the vehicle over, and frankly the reason's irrelevant. It's a minor traffic offense if I remember right. So they were pulled over. The officer testifies that it's dark out. He comes up to the car and does, quote, a quick scan with his flashlight of the passenger area, the front seat area where the people are. And during this quick scan, he sees a baggie, a clear plastic baggie containing a hard white substance, kind of looking like a rock, sitting on the center console, so directly between the two people in the car. They're just sitting there. There's the white substance in a baggie. Of course, he gets them out. Later, they determine that substance to be cocaine, and the passenger is charged with possession of cocaine in Coward. So the issue is this passenger in possession, legally speaking, of this contraband? He's in the car after all. It's right there after all. I mean, it's literally inches from his body. Is he in possession of the cocaine? The Coward court said no. Simply being right there next to a car in proximity to the substance is not enough to be in possession of it, because there's no proof that this gentleman, Mr. Coward, actually knew what cocaine was, or that he actually knew it was even there. In the Coward court, they said it's important to note that it was dark and there was no evidence that the white substance was visible to Mr. Coward sitting in the passenger seat. The officer had to illuminate it with his flashlight for the officer to even see it. So it was in plain view once it was illuminated with a flashlight. So Mr. Coward may not have even knew it was there, much less known what it was. So that's a simple example, and a very good example, a very clear case where the court said that simply being in the vehicle does not mean that you know that it's there and that you know what the nature of it is. And those are two important issues for a constructive possession case. This comes into my work a lot in marijuana cases where I work with defendants charged with possession of marijuana. A lot of times it's in a vehicle, and we have to argue basically that they didn't know it was there. That's the Commonwealth's burden to prove possession. This is not a technicality. This is the Commonwealth's burden to prove beyond a reasonable doubt that the person they've accused of a crime actually knew what they were doing and actually did the crime. This is not a situation where they just borrowed a buddy's car and there happened to be some stuff in there and they didn't realize it, and now they're being accused of a crime. The Commonwealth has to prove they knew the substance was there, they knew what kind of substance this was, knew the nature of it, and also had to be in control over it. So just being in a vehicle with contraband is not enough. Now, we'll get to in some other videos to discussions about odor and different things that can make it enough, but there's also important burdens for the prosecutor to bear even when there's an odor of marijuana or other contraband. So hopefully that helps to give you an idea of what it means to be in possession. You can't just be sitting near it. That's not enough according to the Coward case.